On the morning of April 27, 2026, the doors of the United States District Court in Oakland opened for jury selection in a case that will decide the legal architecture of artificial intelligence. Sitting at the plaintiff's table is Elon Musk, whose personal net worth sits near $713 billion. He provided the first major block of funding to build this organization. Across the room is Sam Altman. He is the CEO of OpenAI, an entity now valued at $852 billion. He is flanked by his co-founder, Greg Brockman, and an array of lawyers representing Microsoft, their chief financial backer. 11 years ago, these men shared an office. They incorporated their lab as a nonprofit, agreeing to build artificial general intelligence openly to protect humanity from the risks of corporate monopolies. Now, they are facing each other across a courtroom. This trial forces the legal system to address a question it has avoided for years. Who actually owns the underlying capital of the artificial intelligence boom? The scale of the requested damages reflects what is at stake. The initial filings sought $134 billion, which has since ballooned to $150 billion. The lawsuit insists none of this money goes to Musk. Instead, every recovered dollar must be deposited back into the original charitable foundation. Furthermore, the filings ask to remove Altman and Brockman, collapsing the for-profit arm back into a pure charity. Directing potential damages back to the foundation shifts the focus from a billionaire's financial recovery to a quest to reclaim charitable property that the plaintiff alleges was unlawfully converted into a profit engine. To trace exactly how that profit engine was built, we have to look back at the original paperwork. In December 2015, the founders signed an agreement establishing a nonprofit research laboratory. Musk provided roughly $40 million of his own money to get the project off the ground. The alignment held for 3 years before a strategic dispute split the board. According to later reports, Musk wanted to fold the AI lab into his electric vehicle manufacturer, Tesla. The rest of the leadership refused, and Musk walked away from the board entirely. In 2019, the organization executed a structural pivot, creating a capped profit subsidiary, legally attached to the nonprofit foundation. This mechanism allowed them to accept massive outside investment, opening the door for Microsoft to inject billions of dollars into their research operations. Over the next 5 years, that subsidiary launched ChatGPT and captured a dominant market share. A small research lab, originally funded by charitable donations, is now scheduling a $1 trillion initial public offering for the end of 2026. The plaintiffs intend to prove this transition was an intentional corporate conversion. Their primary evidence comes directly from the private diary of Greg Brockman, OpenAI's co-founder and president. These personal notes on corporate strategy, kept out of the public eye for years, were unsealed for this trial. One entry in particular outlines their internal planning. The text reads, "Our plan. It would be nice to be making the billions. We've been thinking maybe we should just flip to a for-profit." Another passage from the same diaries weighs the moral implications of this shift. The writing acknowledges the ethical complications of restructuring the nonprofit and taking it away from Musk without securing his prior agreement. These entries give the jury a window into the founder's thought process before any legal defenses were prepared. The plaintiff's attorneys are using these words to argue that the executives systematically dismantled the charity to build a tech empire. The defense tells a contrasting story. Their filings argue that Musk was fully aware of the need to pivot. They point out that he actively participated in early discussions about how to raise the massive amounts of capital required to train frontier AI models. The defense frames this entire proceeding as an attempt to slow them down. They argued this is a harassment campaign born of competitive friction, designed to drag the market leader into court while Musk's own AI venture attempts to catch up. But a complex procedural hurdle could render these arguments irrelevant. Depending on the claim, the statute of limitations restricts lawsuits to a specific filing window of 2 to 4 years. The plaintiffs are countering with an ongoing breach theory, arguing that each new corporate restructuring creates a resetting clock that keeps their lawsuit legally viable. If the presiding judge rejects the ongoing breach theory, she could rule that the plaintiff waited too long to file. The entire case, along with the fate of a $1 trillion company, could collapse on a missed deadline before the jury even evaluates the evidence. What happens in this specific dispute carries massive economic weight. The corporate models tested in this room form the legal architecture for almost every major player in the artificial intelligence sector today. We can see the scale of the structure here. Companies like Anthropic and xAI operate under hybrid models linked to a public benefit or nonprofit core. If the court rules that converting a charitable mission into a market-driven subsidiary is unlawful, it instantly threatens the stability of the billions of dollars invested across the entire ecosystem. Conversely, a ruling in favor of the defense secures the system. If the court validates the legal transition, the path clears for the scheduled trillion-dollar initial public offerings, and the capital pipeline continues to flow without interruption. The market is watching closely because the verdict will determine if the current AI boom was constructed on top of an unsustainable legal loophole. The resolution of these immense financial pressures currently resides in a single building in Oakland. The 9 jurors in this trial are strictly advisory, meaning the ultimate authority rests entirely in the hands of one federal judge. Future legal briefs regarding nonprofit governance and mission scaling will cite this ruling as the primary precedent for how mission-driven entities interact with private capital. At what point does a nonprofit cease to be a nonprofit? The court must define exactly when the original promise starts to dissolve. Is it when computing power becomes too expensive for donors to support? When the technology becomes too valuable to freely distribute? Or simply when the people running the organization decide their original ideals no longer apply? The answer will rewrite the rules for every research lab, every charitable trust, and public benefit corporation trying to balance the demands of a higher mission with the realities of market value.